minimal cost coming out from separate property to community, this literally kind of makes it easy for the court to more or less just say, look, we're going to lump it in. We're going to count it as X or Y, so you don't have to fight about it.
Yeah.
And that's, little things putting down, well, yeah, that was my car, but you added the $2,000 this, that, and the other to it. So is it, community funds being used to enhance my separate property? Look, if it's inconsequential sometimes, you don't count it. And likewise, I know you said that you pulled it from a succession site. Something else that people worry about, what about my inheritance? When you get that inheritance, it is definitely your separate property 9 times out of 10. But you have to be careful what you use it on, what those fruits and what the growth on that inheritance does. Okay, your parents gifted you with this retirement account that they socked money away in for 20 years without you knowing. Well, what about that now? What are those funds now? Sure, the base value when you were married is absolutely your separate property. But if you didn't reserve certain fruits and revenues, and they were done through no hard work or labor of your action, that could be community value.
Yeah, that's another great word from family law is commingling, right? And so if you inherit money, it's separate property. Now, if you take it and you put it into the joint account, the community account, and you take out 500, you put 1,000, you take out 2,000, you put 500, and it starts getting commingled, and we can't readily identify it from looking at a few bank statements, then you pretty much lost your right to that separate property.
Yes and no.
I knew you were going to say yes.
The one word.
Such a good lawyer.
The one word you didn't add to commingling was hopelessly commingled. That's the phrase where you see in court cases where it was such a nightmare that the court would throw their hands up. You'd have 2 CPAs, 2 attorneys, sometimes a third CPA, everybody arguing for it. Each party has their own expert. The court may have their own expert to try to figure it out. That was very prevalent, like we said, when in the 80s when divorce really ramped up, community property, custody was just nasty. Things like that. You can't figure out where the money went. Now, with the advent of electronic banking and records being held longer, and a judge who's willing to do the work, and one of my favorite judges here, locally in the 15th JDC, said, look, it's not that really hopelessly commingled anymore. If I can get the records, I'll figure it out, or the attorney should be able to figure it out for me. So that's why I say yes and no. A lot of it depends on records. How far back can you go? The IRS, and again, whoever you have for your tax podcast can probably answer this better than me. IRS only has to keep your returns for so many years. If you're dealing with a 30-year marriage, forget about divorce documents for divorce from 25, 30 years ago. But recently I have had a case where I had to go back 17 years. Tax records were gone. Bank records, forget about it. They were gone at the 3 or 7 year mark. How did we get financial details? Social Security benefits. So all the quarters, everything they put in, Social Security kept that better than the tax records to figure out what that person was grossing and or netting. Some minimal details, but details nonetheless for the income for those years. That was 20 years before.
So if you're listening to this and you get some separate property from an inheritance or some type of other form of separate property, keep it in a separate bank account, because then you don't have to pay for 2 or 3 lawyers. You don't have to pay all competing CPAs. You don't have to ask the judge to go through spreadsheets for the last 10 years. Keep it separate and don't hopelessly commingle it in the bank account.
And sometimes you have to give notice. The laws changed right around when you and I were taking the bar. I think in 08 or 09, the laws changed on what kind of notice you had to give the party, saying, look, you used to be able to just have a document, stick it in a dresser drawer, right? The dresser drawer deed that we learned about in law school. Put it in there. 20 years later, look, honey, I reserved all these fruits from this separate property. You don't get any of it. No notice. Now you have to give them notice. Ideally, you give them notice in front of a notary. They sign off 2 witnesses. You file it in the clerk's records, especially if it deals with some kind of physical property, immovable property, land, or a business. They get full notice. They can't come. A lot harder to argue against it,
Yeah, I would imagine that most of the divorces, like when it comes to community property here in Louisiana, it's not the Hollywood, multi-million-dollar situations. It's usually a car, 2 cars, a house, some bank accounts, maybe a retirement account or 2. We're not talking about millions and millions and millions of dollars.
Every now and then, I do have some high earner clients, people that have inherited a family business, or someone that is a doctor or a big business owner where their income is greater than $30,000 a month, let's say. For child support purposes, it's off the charts. The court's willing to do what they want to do. So there are some big ones like that, and then there's lots of small ones and everything in between.
Do you like taking the big ones on?
I don't mind it. It really, a lot of it, to be honest with you, the wealthier the client sometimes, the less animosity in the case. They know they don't want to pay an attorney. They have plenty to go around and split up as long as they feel like they got a fair and adequate, judgment, that their voice was heard and they participated in it. They're fine.
Do you ever take on the husband and the wife together and help them resolve it? Or you always handle one party?
I have to take one part. Ethically in Louisiana, you can't represent both parties. Attorneys, especially some well-known and attorneys with more experience than me, some attorneys been on the bench, been a member of the bar for 30, 40 years, have done that in a roundabout way or try to be sneaky around it. I can only represent one party. I make that very clear when one person comes in for a consult. If one person meets with me and they bring the other person, I said, look, leave that person in the car or up front. They never enter into my inner sanctum in the back, and I make it very clear. That person retains me, and I tell them, look, I'm more than willing to work with the other party. They're free to go get an attorney. They can ask me questions. I will answer them honestly and openly. Now, if they don't ask me the right questions, I don't have to answer them because I'm not representing them. Kids with cases, I always try to put the kids first. Next, it's my clients. Clients that don't have any kids, they're number one. The other party's always going to be second. But again, the client and the facts drive the case more than me and my opinion of things.
Let's assume that I send you a friend of mine who goes and says, I want to file a divorce, me and my wife, or me and my girlfriend, and we have kids. Everybody's on the same page. You have them. I'm sure you could prepare all the paperwork.
Correct.
Right, for your client, and then advise the other party that they should get an attorney and probably put that in writing somewhere. Right. And they can waive that right and then sign off on the paperwork. And then the two of them work it out. They pay one attorney and you could file the paperwork that way.
Right. So that's...
Am I off base there?
That's very common.
Okay.
Typically, the only time you have to advise another party in writing and get that in writing from them, an unrepresented party, is community property. That's when I do it. But for like simple service of a divorce, rather than a sheriff's deputy go knock on their door, come into my office. I'll meet with you up front. You're not my client. My secretary will be there watching third-party eyes the whole time. Sign off on a waiver of service. Look, this is your chance. Go talk to an attorney. This is what we filed. I can email you in a couple of days with what the proposal is from my client, your soon-to-be ex-spouse, and maybe we'll get it all done. Then they'll come back in, and if it deals with certain things, I'll get them to sign off in front of either me as a notary or a third-party notary with two witnesses, and they could settle everything. I'll file it. My client signs off. Their attorney underneath. The other side is improper person or pro se, representing themselves. Instead of an attorney's address or contact information, it's that person's address. Boom, you're fine and done.
I would say that they're spending half of what they would be spending had she hired a lawyer or he hired a lawyer, the other side, but it's really more than half, right? Because just by the adversarial nature of divorce, you got to be cutting more than half the cost if they agree and
if they agree, absolutely. And a lot of times it unfortunately depends on the attorney on the other side. Are they going to try to build a case and make some issues that aren't there? Are they going to be direct forward and get it done? And so much of it doesn't depend on the client sometimes, or even the facts. It depends on the other attorney and how they would approach it. And what I like to do, I like to try to predict what I think is good, fair, reasonable, equitable. Look, this is how I'd like to see your case go based on what you've done in the past and where you're at now. And what will it take for us to get there? Are we going to have to litigate it or not? 9 times out of 10, a client will follow my lead. They'll say, yeah, this makes sense. Okay, I didn't know about that. Now you've informed me. I'm okay with this, and that's kind of where their case goes, and it's up to them at that point.